Good morning, good afternoon, good evening, whatever it is with everybody. I hope you're all well. I'm all set. I just need to tweet it out and then I'm done. How efficient am I? Let's tweet this bad boy. Oh, always allowed. Yeah, that's fine. But let's tweet this bad boy out, shall we? We've got a bit of a surprise today. We've got two streams today. Oh, YouTube fair play to you. Oh, hello. Who's this? Nice, 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 nice. Right, where's my Twitter? There it is. There it is. Just going to retweet it. I'm not going to make a fresh one. Do you know what I mean? So feel free to say hello in chat if you want to. If you don't want to, that's absolutely fine as well. Trying to figure this one out. Where's that gone? Oh, here we go. Oh, Carwyn, closing arguments. Guilty as sin, boy. Guilty as sin, boy. So this, I mean, obviously I'm not sure. I wasn't sure until he went on the stand and he said, "Yeah, the my mother got killed. I answered the door for two guys. They came in with guns and they put us down the basement, threw my mother against the wall, um, threw something at her, went upstairs, got a knife, stabbed her, then told me that if I contact the police, they'll kill all my family. Showed a picture of my family, said they'd kill them all. So I just went on the run." It's like, dude, make a bloody better story than that, eh? So that's his excuse. That's why he went on the run. It's like he's a lawyer, and that's the best story he could make up. It's like, dude, sin. Um, but so closing arguments, cars on this one. Obviously, you could be finishing work before long. Once that's done, I'm starting a new stream then. Uh, Travis Rudolph, NFL player who's accused of murdering some people. That's actually on right now, but I'm going to be playing it as soon as these guys goes into deliberation. So that's what I'm doing. Oh, that can't. You would laugh if you saw it. You'd laugh. Yeah, that's true. You probably have. Honestly, I think we all were like, "Is that it? Is that it? Are you kidding me? This could be the quickest, or should be the quickest verdict in the whole of the world." Because like, what's to discuss? Like, um, once done, fine. It's all set up. Quite a day of evening. It's a bit cold now, but it'll do. So yeah, so I got that one on. So that's starting today. That trial. So that's gonna be today, Thursday, Friday. Then, if you haven't seen the Kaz on Twitter, um, I am doing a Johnny Depp Amber Heard trial. That's going to take, I think, 27, 28 weeks. And it's going to be every Saturday, 7 p.m. I'm streaming that. And it'll probably be like, depends, 4 to 5 hours sometimes every Saturday night. Some of it might be like less, I'm not sure. But I'm going to play it at 1.25 speed. So if you haven't seen it, Kaz, hey, you and the missus, Johnny Depp. Mrs. Bound to like Johnny Depp. Stick it on. Romantic, innit? Having me speak over some date or something, do you know what I mean? So, but yeah, that's every Saturday now, which I don't know why I did that. Well, it's basically, I think there's 25 episodes, 27 episodes I'm doing, so let's work it out. Starting this Saturday, then 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 1, 2, 3, 24, 25, 26. I think it takes us to literally 25th of November. Yeah, so this program, apparently there's been 3 episodes of it, and apparently it's total trash. They said don't watch it, so I've not watched it. People who know the trial well said do not watch that. It's complete fluff. You need to watch it. So that's why I'm doing it because everyone's on my back about doing it, but they want to do like a 5 week trial, So I want to continue doing the live trials. So this means every Saturday I can stream it. That'll take me literally to the end of November then. But I might have to miss like a Saturday here or there. So it might take us into the middle of December. But the beauty is, like if you miss a Saturday, it's not a problem. You just go back and watch it. Do you know what I mean? So it's streamed. And you'll be skipping all breaks, skipping lunch breaks. So you don't have to worry about any of those stuff. And it'll be played, depending how long it's going to be, might be played at 1.25 speed, um, 7 p.m. our time. I don't know, maybe no one's going to watch it, but everyone keeps speaking about it. So, and the inside jokes. Apparently, there's only 2 episodes that might be a little bit boring, and the rest of them apparently are really, really good. So the first 2 weeks are going to be about the deposition of the divorce, which is nothing to do with the trial, but it gives us a breakdown of who Amber Heard is. So that's the first 2 weeks. I think they're going to be like 3 hours or 4 hours. Oh, not too bad. So yeah, I don't know. Something different. I'd say to everyone, if they don't want to follow it, that's fine. But pop in, say hello, something. Um, I'm just trying to attract new viewers as well. So I don't know what's going on today because it's only you here. Literally only me and you guys so far. And Rumble, no one on Rumble either. What's going on? Don't understand it. Oh. You see, yeah, no, I agree. You're here. Been missing for a few. You've been missed. It's normally you come in first, we start with the tea, speak to you for the first like hour, whatever it is. Then I know like when it comes to like 4 o'clock, I know Kaz is itching at that point, So you have to go quiet then, and then you're gone. Um, and by then the other people are here, so so it's all good. Um, so yeah, bloody hell, this is going to take us. You're right, nearly to Christmas. Bloody hell, that's a big commitment I've just made. Without thinking, I just did said I'd do it. Didn't think of the consequences, did I? So I'll be streaming 6 days a week, pretty much. And I've got the idol stuff to record. Bloody hell, busy, busy boy. Just need to figure out how to get more people to watch. I can't figure it out. Edit, no, view here. Let's. Was Darwin like the video? I'm not sure. He says he's the best, but I'm not sure he's liked the video, yeah? Let's go in there, analyze. He's just done it. Look at the boy, he's just done it. What happened Monday? Right, so um, if you want to see it, it's on my channel, right? There's a video. Um, yeah, drop by. I did see it. Just have pop up. There's a video there that shows it. Skip it all. Until we come to the video, it'll show you everything. Then what happened. But basically, all that happened was he agreed that he knew everything that was coming out, like what he's been prosecuted for, and then so when it came with right, is your client ready to plead guilty, not guilty? The lawyer Ann Taylor stood up and said, we're silently, we're not going to say anything. Basically, we're just going to stand silently, which means that the judge takes that as a not guilty plea. there's a lot of rumours about what that means, whether he's playing games and stuff like that. But apparently, it's quite common that people do it, and it might be a part of a plea agreement he might be looking for, or it's all speculation. No one knows why he didn't say not guilty. Um, so now, from Monday, the prosecution state have got 60 days to decide whether they want to proceed and make it what do you call it, a death penalty trial or not. So it's up to them. Apparently, if it's a death penalty trial, it's a little bit different. It's a little bit harder. But the trial itself starts, I believe, October the 2nd, and they predict a 4 to 6 week trial. But with everything, no one actually knows, but it could be delayed till next year. I don't think it's happening in October 2nd. I'd be very surprised, especially if it's a death penalty one, that they're just going to do it October 2nd. You just can't see it happening. So, I don't know. Whoever else is here, please say hi. It's only me and Carolyn here, so we don't bite. Say hi. But yeah, but if you want to see the actual arraignment itself lasted probably say 5, 6, 7, 8 minutes. And so on my video, if you want to see, as I say, it basically the whole video is just me talking shit, and then we watch it. Um, a lot of people say he was aggressive, and I did. It was all normal. It was all normal. I don't think that he did anything wrong, in the sense of he was too aggressive or anything like that. So there we are. What else is there? No Mad World, no Spider Girl. What's going on? Just me, Carwyn and me, and there's a few people on Rumble, I believe, and there's someone else in on YouTube. Don't have to say hello and anything. It's all good. Oh, Giovanna, Gio, how are you? Now, Gio, can you hear me this time? Because we got lost yesterday. I couldn't believe that you couldn't hear me. I was like, I just had to look at my mic. I was like, Gio, I'm speaking to you. Gio. I hope you're well, Gio. It's only me and Carolyn here at the minute, so um, so yeah, there's not many of us here. I gotta go do the banners. Um, closing arguments there, and then we'll do this. And this. So Gio, we're doing two trials today. So hang on, let me just type this and explain it. We're doing. Um, so let's explain what's happening here now, right? We say this. Sorry, I couldn't do two things at once. So hopefully that explains it, right? So we are. You cheeky bugger. Hi, Gio. Cheeky bugger, Carolyn. So I think this trial is going to be another couple of hours, 2, 3 hours probably, if not a little bit more. Once this is complete, I'm closing this down and going and starting a brand new trial on another link. So if you've got notifications on, it shouldn't matter. Carolyn, you won't see it because you'll be off work by then. Um, yeah, so it's the Travis Rudolph trial. And because I want to do playlists, I need to start a new trial, but we will still be doing a watch along for the result of this trial, and that will appear um, in the other trial, and I'll edit it and put it in the play. Oh, it's confusing, but it'll make sense. So yeah, Gio, um, yeah. So the two streams, Gio, today. This one and another one. So hopefully you get the other link if you're still around. Everyone else, say hello in chat if you're around. If you want to have a chat, if you want to say something, we're putting our hands in the air, shaking it like we just don't care. I got my NFL top on today. Oh, you can't see it because of the banner. Let me get the banner down there. And then NFL, the Colts top, Michael Pittman Jr.'s top, squeezed into it because it's doing an NFL trial. So, oops. Yeah, and Gio, the Travis Rudolph one is a murder trial, so you're going to enjoy it. So, because it's already on now, so I'll be playing at 1.25 speed just to catch up and skipping all breaks. And so then by tomorrow we'll be all caught up. You know what I mean? So that's the plan anyway. Hopefully everyone that is here then will join up on the other link then. Hang on, let me just hang on. I can put the link. The thing is, you can only copy and paste this link. I think you can't. Yeah, NFL X Player Trial. Yes. Um, I'm not sure if you can copy and paste that or not, but essentially that's going to be the. It's up on my channel. It's there ready. You'll see it all. Press the notification button, and it should pop straight up. But that's going to be the next link basically for people to see. So yeah, hopefully everyone's okay. We're a little bit late starting. Oh, Spider's here. Oh, I didn't see it. Oh, I missed it. Yeah, it's finally started, Spider. It's finally started. Um, so we started actually at 8 a.m. Eastern, so it's actually on now. They're doing open arguments now. But of course, obviously, I want to finish this. So what I was saying to the guys is going to be two trials today. Um, but at the end, I'll say it again to everybody. We're closing this one down, starting a new trial in a new lane. Sorry to confuse everyone, but that's what we're doing. Um, I need like 10 minutes before we started to set up the Rumble because Rumble is a nuisance. You can only set up one video at a time. So we got Spider Girl, we've got Carwyn, we've got the one and only Geo in the chat. There's more people here, but I don't blame people if you don't want to chat. Luna's probably on the way. She's still in bed, but she'll be on the way later. Um, Lefty's probably going to hop in at one point or another. So yeah, we'll see. Nedworld as well is missing. She's normally here. Oh, to be fair, no, she comes in a little bit later because she's got to look after her kid and stuff. So I got my little niece here today, 3 years old. She brought me in my lunch. This is my lunch. That's what she said. She made it for me specially. She goes, "Oh, good the land. This is your lunch." So I was like, "Oh, just wow, thank you." So special lunch for me. Just got to live kids, didn't he? That's exactly why Spanigal. It's just about we're still going to watch the verdict on this trial there. I'll stream it there. Um, hang on, let me refresh then. No, I'm ready. It's no, we're not waiting on Rumble. I'm just waiting on Law Network. I don't get. That's the thing, Joe. I don't get Core TV. We don't get it in the UK, so that's why I can never watch Core TV. So let's not have any spoilers here, guys. If you're watching Core TV, please don't spoil it for anybody. Um, so I have to wait on Law Network, as you can see the screen here. Well, that's a bit of a shame then. Yeah, but it'll be here now. Patience now. It'll start because they're supposed to be linked together. I'll refresh again. Yeah, so it's not me. It's wait for Law, and it'll probably start in line with Core TV. So I wouldn't worry too much because it's the same. All right. Um, yeah. So it's as you can see the chat's going in Law Network. So it's just there. We're just waiting for them now. Interesting. Yeah, we get Core TV website, but we don't get Core TV live stream here in the UK. I'm not sure if you have to pay for it or anything like that, but you know, I don't like Core TV because it goes to adverts anyway. So I mean, I'm happy with this. But there it is funny because sometimes they do. I think the bigger cases they might play it on the website, but not these kind of cases. Only like Gwyneth Paltrow or Alex Murdoch kind of cases. Um, Looking forward to it. Hopefully see you sometime. Hopefully see you pop in. So just speak. Yeah, people are, some people picking up interest about the um just saw the Madeleine McCann thing in Germany, trying to find her there. I don't even know. That's such a sad story. I don't not get into it right now. Um, so there's a little bit of a interest now in the Johnny Depp Amber Heard stuff starting Saturday. Some people showing a bit of interest. Hopefully, people will come along. Um, and if whenever she's available, Spider Girl will be on stream. She doesn't. Well, she does know that anyway because she promised it. So am I, Gio. So am I. I'm very. That's why I got my NFL jersey on. I'm really excited. It's just I have to play this out because we watched it all. This is a good trial as well. So, but I'm super excited to watch the NFL one. I'm with you. It should last. They think a couple of weeks, which is ideal for us. I think a 2 week trial would be nice. This was 4 5 days. I think it was 4 days, which was nice as well. But a good meaty 2 week one would be nice now. Spider's been all quiet now. Where you gone, Spider? Because that's a good question. You actually coming on camera on Saturday? Ah, good, good. It's a Colts t-shirt. It is. I won't lie. I like the Colts, but I'm a fake fan. I'm a fake fan. I like them because of certain things, certain people. I like Frank Reich, but I'm not like if they won the Super Bowl this year, I'd be like, yes, good, but I'm not like a proper fan. Where I'm supporting them every single week or anything like that. I do like them. I like Indianapolis. I like Michael Pittman, but I also like Carolina Panthers, so I also like, the underdogs like Detroit Lions. Um, will be camera free. To be camera free. What's camera free means, by the go? And what's the snacks you're eating? Um, Rosie's going to join us now and again for the Johnny Depp one. Here was there. So no face and Vienna sausages. No face, are you? You chicken. No, that's fine. I did say to you, anytime I want to come on without your face, that's absolutely fine. But chicken, joking. Vienna sausages dipped in Frank's buffalo wing. Okay, at least it's not bloody something disgusting like biscuits and gravy. At least that sounds alright. Biscuits and gravy. Oh, you're mad. Don't tell me you like biscuits and gravy. Jesus. Do you like biscuits and gravy? Yeah. Wow, Gio. I thought you had class, Gio. I thought you had a refined palate. Biscuits, that's it. Yeah. I need to try it. Is it brown gravy or what kind of gravy is it? 'Cause for me, the only gravy is like Bisto gravy. It's like homemade brown gravy. Right, where the fuck is this? Why is it not starting then? Okay. Describe it to me because here we go. It started. I can't understand how you do biscuits and gravy. Right, so it is. Oh, I need my thing. Hang on. Yeah, live stream's on. Live stream's on. I just pressed play. So there we are. It's on now. It's the audio's not. So yesterday I played a lot of it without this. Apparently there's lots of echo. I didn't know. I didn't know what told me, so I didn't know. So if there's anything wrong with the audio, I can't hear it. So just let me know. Sausage, biscuits and gravy. Chicken biscuits and gravy. Bacon gravy over biscuits. Oh, white gravy. I mean, that's madness. How can you have white gravy? There's no such thing as white gravy, man. White gravy. White gravy. I mean, half the time, guys, I think you're taking the piss. White gravy. To the win, if you're still here, come on, man. You've got to support me in this. There's only brown gravy. There's no bloody white gravy. You got white sauce, like white cheese cheddar sauce, or parsley sauce, which is white. Yeah, get them. White gravy. What's it even taste like? It's not like proper gravy. Like you say, sausage and gravy, yeah, fine, but it's brown gravy. White gravy. What's in it? I don't get it. How can you have white gravy? That's crazy. I think it's well. I know you're not taking the piss because I'm sure it's true, but I don't get it. What's in the white gravy? It's only brown gravy, man. I don't get it. I'm gonna have to try it because I just don't understand it. No joke. I've never heard of white gravy before. I've heard of like parsley sauce. That's a white gravy. Cheddar sauce, cheese sauce. That's like a white gravy. But what's your white gravy? What is it? Like, what's in it? That's what I don't understand. Like, it's actually what if it's brown gravy? Yeah, I get it, but white. Oh, judges here. I mean, look, Saturday. Now you're taking them. Big Nick now, aren't you? Punchy gravy. Way. I'm not even joking. I'm not saying Nick here. I'm literally taking the piss out of me right now. Why? So good. It's a dessert, man. That's custard. It's custard. White, yeah, white sauce. White sauce is in custard. Flour, milk, seasoning.
All right. Good morning, everyone. Sorry for the delay. Came outside this morning, so it's the joys of living in Atlanta these days, I guess. But I did send you all copies of the charge last night, and I wanted to go over a few things this morning to make sure everything was included that should have been, and see if there's anything else that needs to be added. If you'll go to page 3 of what I sent you, the highlighted portion that says prior convictions, limited purpose. I didn't know, Mr. Queen, if you wanted me to give any kind of instruction related to the Cobb County conviction that was admitted into evidence.
I did not.
Okay.
And Your Honor, may I speak on that as well? There was something that I didn't even think of until I read this. We did use that conviction for impeachment purposes as well. I asked him about it, and so I would ask for that just subsection of the impeachment charge that says having been convicted of a felony.
I don't think that's part of the impeachment pattern.
What is the text?
Right.
Judges can't appropriate the whole thing. I love this judge. They've got up to 2 hours each closing argument. I don't think they're going to use 2 hours each. Then
it's 1:31:45.
The judge has got to give them instructions. Well, you should give it the long instructions, not the short instructions, which I didn't know there was.
130, 145, 130, 140, Judge. Thank you.
Getting to
I think it's under 130, 140. From the attack. Man, honestly, that's the section that will give you modified.
Well, felony conviction and also crime of dishonesty would apply in this case, correct?
Yes.
You're correct, Judge.
So that's 130, 140. Which says, in determining the credibility of witnesses and any testimony by them in court, you may consider where applicable evidence offered to attack, cast doubt upon, or challenge. Which one are you asking me to give? All
Attack.
attack the credibility or believability of any such witness, or cause you to disbelieve. Believability of.
I won't miss you audio in this trial, that's for sure. Hang on, Spider, I need to.
Shelley,
Just fine.
Shelley,
Just fine,
you have
like,
the
uh,
exhibits down there? Okay. Can you hand me number 2? The conviction.
Just finalising stuff for the Jewish PA.
Okay, so which part are you asking me to give? Just go ahead. Spot.
We are asking for and we are asking for credibility or believability of any such witness.
Okay. Mr. Queen, interjection.
All right. We're going to check, give them 140 on proper request. I'm not saying it's not appropriate, but without proper request, we are going to check, and give them 139, 140. I think what would be appropriate, if the court gives it, is attack.
So what's inappropriate about the request?
It's not, it wasn't being given without proper written request. No one submitted a request on it.
Okay, but
When we were yesterday, the state didn't ask for it.
I understand that, but there were a lot of requests that weren't made, that weren't properly made, that I have put in the jury charge that we discussed yesterday. So what's good for the goose is good for the gander. So, all right, so let's talk about what I'm actually going to read then. Evidence offered to attack. Okay. Well, I think all of them are appropriate because you've not only got the felony conviction, you've also got a crime of dishonesty conviction. So I would be inclined to give both of those sections. Evidence offered to attack, cast doubt upon, or challenge the credibility or believability of any such witness. This would include evidence of proof that the witness or proof that the defendant has been convicted of the offenses of
I'm scared of saying anything because the audio's so bad I don't want to miss anything. I'll give the judge a clap. Oh, he's been fantastic. But they're just finalising the jury instructions.
so theft by taking, elder exploitation, forgery in the first degree, and forgery in the third degree. Proof that the witness has been convicted of a crime involving dishonesty or making a false statement. And that's it.
It's just dishonest, just not false statement.
I can post a link about this white gravy stuff. See,
Well, I'm just looking at count 3. This is just the first one I looked at that says
this was
elder exploitation. It knowingly and willfully exploit Claire Hansen, an elder person aged 60, using Claire Hansen's resources through deception, false representation, and false pretense for his own profit and advantage. So does that not include making a false statement? I don't know any specifics of the case, so I'm depending on you all to blank.
Your Honor, I don't object to just doing it dishonesty.
All right. All right, if you'll turn to page 7 under malice murder.
Judge, can you go back for a second?
Sure.
In the court's decision to give 13140, then I guess it makes sense to leave prosecution back in.
Okay. Okay. All right. Let's turn to page 7 under malice murder. What I usually read is it is unlawful and is the unlawful intent to kill without justification, excuse, or mitigation.
Yes. That's what we would ask for.
Judge, I would ask you just to appear behind Hill. There's no defense justification, no defense excuse, no defense thing, there's no mitigation offer.
Okay, well, I think that this just explains the definition of malice murder. So I would be inclined to give it, as I've indicated.
Flipping videos here whilst we're at it, that's why I've gone quiet. I'm going to ask Twitter about white gravy.
Next, let's turn to page 9.
No,
You see there was an as left out. So it should read, in deciding whether the dumbbell as alleged in count 4 is an offensive weapon, you may consider all of the following factors. I left out as. And same on the next page. In addition to the additional element of the offenses charged in count 5, the state must also prove that the alleged victim was over the age of 65. Debated about over the age of 65 or over the age of 65 years old. I don't know that it really matters.
I don't understand that bit. Why? She is over 65.
And I think that's it. Was there anything else? Needed to address?
No.
It's awful trying to run a stream. I'm trying to sit at the same time. I'm not afraid to multitasking. Clip is gone. I've asked Victor about white gravy to see if I'm on my own here or not. I'll post it, yeah. What it does now. Right, so obviously they're probably going to take 5 minutes. And jury in 2 hours max each, which I hope it's going to take 2 hours. And we'll go in.
All right, we're ready to bring the jury out.
It is.
Yes.
Do we listen to the instructions or not? Do you think we should? I'll put a poll up. Let's put a poll up. Put a poll up. Since I found out how to do a poll, I love it. Not a Q&A, no. Not a poll. Do we listen? Closing arguments. This is too long. We wait and move a little bit. We list the due instructions or finish after the closing arguments to begin the new trial. Right, so there's a poll. I can't vote in it, so there's a poll. Vote, see what you think. Leave it up for like 10 minutes. Also, why is no one liking the video? Please like the video, I'd really appreciate that. Same for you on Rumble, guys. Rumble, your message is going to be Lost up the rumble. Fine. Right, so we got one yes. I'm going with whatever the poll does. So we're gonna put them in there. We are staying for the jury instructions. I understand the poll there. I can't vote, so one person I believe has voted that we stay for the whole thing. Fine, I will. We'll do what the majority think I should do. There's 5 people here on YouTube. Sorry, Rumble, you just have to follow what these guys say. To ask 2 options. You leave straight after the closing arguments, or listen to the jury instruction. It should only last an extra half an hour, 3/4 an hour, depending if you stay in a break and stuff like that as well. So stay an extra hour then. Yeah, there is, Gio. It's a nuisance, there is. It is, you're right. Okay. Especially when the audio's so hard as well.
May I move this, Judge? Just
Sure.
a second.
Okay. I can't see the views in 2 hours each. I can't. Right, there's 2 yeses now, so it looks like we will be staying for it all. As I say, which is absolutely fine. I'm going to give it another 5 minutes. And then you've lost your right to vote after that. Because we're a democracy,
Y'all may
not
proceed.
a dictatorship.
Good morning, ladies and gentlemen. Apologize for the delay, but we are now ready to begin with the closing arguments from the attorneys. And as I told you at the beginning of the trial, the state has the burden of proof in a criminal case, so the state has the right to speak to you both first and last. So I'll call on the state to begin.
Keep it short now, keep it short. Don't. Not a long one now. Don't act like you did when you crossed him last night. A lot of people like the cross. I hated the cross. I hated her cross. But I think she's a very good attorney. I just hated her cross. Right, shut up.
Good morning, ladies and gentlemen. As Judge Johnson just explained, the state has the burden of proof in this case and in every criminal case. And so that's why I'm going to have the chance to talk to you first. Then the defense will have the chance to give a closing argument, and then I'm going to have a chance to talk to you again. First, I'm going to address kind of the boring stuff, or what seems boring, but it's really important, and that's the law that applies to this case. Again, we have the burden of proof. We have to prove each of the charges beyond a reasonable doubt, and that is a burden that the state gladly welcomes, and that is imperative to the criminal justice system. And I know that you all have seen on TV and know that the state has to prove each of the elements and each of the charges beyond a reasonable doubt. Not turned on here this morning. Well, what does that mean? Beyond a reasonable doubt, it sounds like such an ambiguous term. But as Judge Johnson is going to instruct you in a few minutes, a reasonable doubt is the doubt of an impartial juror honestly seeking the truth. You know, when we questioned you during voir dire at the very beginning of this trial, one of the reasons that we asked you many of the questions that we did about your background and about your experiences to make sure that each of you would come into this trial without any biases as impartial jurors, and that you would come to a verdict not based on your past experiences, but based on what you've heard in court over the past couple of weeks. And we thank you for being here and being those jurors. But Judge Johnson is also going to instruct you that reasonable doubt is based on common sense. It's based on reason. And that is really the second thing that we were trying to learn when we questioned each of you at the beginning of this jury trial. And as I mentioned in opening statement, after trial, I've been practicing as a prosecutor for 16, 17 years. And after every trial, I get calls or I get approached by jurors, and they always say, why? Why did you put me on this jury? And there's no specific reason, no specific answer you gave that is the reason that you're here. The reason each and every one of you is here is because you all struck me and Mr. Emmons as folks who would use common sense when listening to the evidence in this case and deliberating and coming back with a juror. So thank you for being those kind of folks, and thank you for being here. And I'm going to ask that you follow the law and use common sense and view the evidence through the lens of reason and through the lens of common sense. Now, reasonable doubt is also not certain things. It's not to a mathematical certainty. The state does not have to prove the charges to 99, 100, and 110%. It's also not beyond all doubt. And I'm going to go a little bit further into that in a couple of minutes, but there are always going to be doubts because we can't videotape every single murder and every single criminal incident that occurs in DeKalb County. So you're always going to have questions in your mind. Reasonable doubt is also not a possibility. And you are not, as jurors, to go out and look for doubt. Reasonable doubt means that if you came in here with an open mind, not knowing anything about the case, and after hearing all of the evidence and looking at all of the exhibits, you believe that the defendant, Richard Merritt, committed each of these crimes. If you reasonably believe that, then you can and you should convict. My favorite way to think of reasonable doubt and what beyond a reasonable doubt means is to think of it like a puzzle. When you sit down and you start putting together one of those gigantic jigsaw puzzles, you may start at the edges and work your way in. You're going to get to a point where you see something like this. There are pieces missing. There may be questions as to what color the eyes are or how many teeth this guy has. But because each of you is a reasonable person, you are able to look at what's there and say, yes, that's a tiger. And you know that beyond a reasonable doubt because you can put the pieces together in your mind based on what you do know about the case and the facts that the state has presented. That's just like a criminal case. You know, I don't know, and nobody will ever know, the conversation that Shirley Merritt and her son had before he murdered her. We're never going to know what clothes he was wearing that day or what he did with Shirley Merritt's cell phone. But what we do know are the facts that bring us to the proof of the elements of each of the charges in the indictment. We don't have to prove all that extraneous stuff. All we do need to prove by law is the charges. And we're going to go over those in a couple of minutes. Additionally, there are things that are not required by law when you render a verdict. The first is scientific proof is not required. And I am certain the defense is going to hammer home how there was no DNA evidence that proved that the defendant was holding that dumbbell. There were no fingerprints on that knife that proved that the defendant was doing the stabbing at the time of the murder. But none of that is required by law. In fact, the law recognizes how difficult it is to get scientific evidence. And you all heard from witnesses that this ain't CSI. Alexandra Jason, remember her? She was the DNA expert from the GBI crime lab. She testified that she tested the DNA that was rendered from the hairs that were found in Shirley Merritt's hands, and all the hairs that could be tested positively were matched to Shirley Merritt. And she also testified about that dumbbell. Yes, they were able to obtain a swab. There was DNA on that dumbbell, but there wasn't a sufficient amount to come to a conclusion. She said, yes, there was DNA, but because there was so little, we couldn't determine who that DNA belonged to. Now, that doesn't mean that DNA did not belong to the defendant. It just shows that it's inconclusive. And you know what Ms. Jason said that was really important? She said, the crime lab really doesn't like to test for contact DNA because it is so often inconclusive. It's so rare that we get that kind of result, especially when we're dealing with a metal object like a dumbbell or a plastic object like a knife handle, and not something like clothes where skin cells would get trapped and stay. The law does not require forensic proof. Again, we go back to those fingerprints. And as you heard from Jesse Worley, the fingerprint expert, not every item is conducive to containing latent prints. A plastic item that has some texture, like the knife handle, it just doesn't always hold on to those skin oils that would leave the latent prints. Same with the dumbbell. Because it was textured, it wasn't something that was likely to produce a latent print. Now, that doesn't mean that the defendant didn't have his hands on those items. It just means that there were inconclusive results, which is what we expected and which is okay because the law doesn't require these things. Finally, the law does not require an eyewitness to have seen the incident. The law, again, recognizes that when you've got a murder that occurs in somebody's home, there's usually not going to be somebody who sees what happened. These are the kinds of crimes that occur in private. And we're going to talk a little bit more about eyewitness testimony in a couple of minutes. But first, I want to go over the charges in the indictment. As Judge Johnson read to you, there are several charges. They are felony murder, 2 counts of felony murder, 1 count of malice murder, 2 counts of aggravated assault, and 1 count of possession of a firearm during the possession of a knife during the commission of a felony. Those are the charges against the defendant, Richard Merritt. And I want to go through each of them because it's the elements of each of the crime that the state has to prove and nothing else. And the first charge that you will see when that indictment comes back to you and you all are deliberating is malice. And the elements of the charge of malice murder are that the defendant did unlawfully cause the death of Shirley Merritt with malice aforethought. That's all we have to prove for you to find the defendant guilty of that charge. It sounds pretty simple, doesn't it? But what is malice? Well, Judge Johnson is going to read to you that malice is the intent to kill without justification, excuse, or mitigation. It is not necessarily ill will or hatred, and it does not require a proof of motive, because we can't read the defendant's mind at the time that he bashed his mom's head. It does not require that we prove premeditation. This isn't something that he had to plan during the course of the day or even hours or minutes before the murder occurred. Malice and the intent to kill can be formed in an instant. He didn't have to have malice the morning when he woke up. He didn't have to have malice while his mom stood there making his spaghetti. When the defendant made contact with that blade to his mother's skin, that's when we have to prove that malice occurred. And again, we can't read the defendant's mind. We don't know what he was thinking when he committed these offenses. And the law, again, recognizes that, so that it allows for malice to be implied. You all can imply malice existed based on the circumstances of the murder and what happened before, during, and after he killed Shirley Merritt. It can be applied when no considerable provocation appears. You didn't hear any evidence that poor 77-year-old Shirley Merritt provoked this murder. When the circumstances show an abandoned and malignant heart. That's actually what the law says, an abandoned and malignant heart. During this trial, you did get to see some photographs of the crime scene and of the autopsy, but out of respect to Shirley Merritt and to her family and friends who are sitting in this courtroom, I didn't publish all of those. But I will submit to you that when you go back into the jury room and you see the photos of what this man did to his own mother's face, you will find malice. Look at Exhibit 28 and look at Exhibit 62. Those are photographs of what malice looks like. Proof of motive is not required. Again, we're going to talk about what the possible motive is in a few minutes, and I'm going to go over it with you. But the law recognizes that we can't read the defendant's mind. We don't have to prove what he was thinking. We just have to prove his actions. As to counts 2 and 3, the defendant is charged with felony murder. And to prove felony murder, the state has to prove that a person commits murder when, in the commission of a felony, that person causes the death of another with or without malice. So basically, the question is, did the defendant stab his mom with a kitchen knife? And in doing so, did he kill Shirley Merritt? And did he bludgeon her in the head with a 35-pound dumbbell? And in doing so, did he kill her? Again, we don't have to prove premeditation. We don't have to prove motive. All we have to prove is that he committed those actions. Aggravated assault. It's charged in counts 4 and 5, and we've charged it 2 ways. Aggravated assault is when a person commits an aggravated assault when he or she assaults another person with a weapon, which, when used offensively, is likely to or does cause serious bodily injury. Well, the serious bodily injury shouldn't be a problem, but we've charged this 2 different ways. First, that the defendant committed aggravated assault against Shirley Merritt with a knife, and second, with a 35-pound dumbbell. Again, motive is not required. Premeditation is not required. Only that he committed these acts, that he assaulted Shirley with these two weapons. The last charge on the indictment, I'm not even really going to talk about because it speaks for itself. It's the offense of possession of a knife that is 3 inches or longer in length during the commission of the offenses previously charged. I anticipate that in a few minutes when the defense gets up here, they are going to talk about what kind of evidence we have presented versus what kind of evidence that we haven't presented. And they're going to make a big deal about how the state has met its burden of proof only on circumstantial evidence. And that's okay. The judge will charge you that there are 2 different kinds of evidence. The first is direct evidence and the second is circumstantial evidence. Now, direct evidence, as the law states, is the testimony of a person who asserts that he or she has actual knowledge of a fact. Direct evidence, it's basically eyewitness testimony. And as I already explained to you, this kind of crime is not going to happen in front of an audience. It was the defendant who chose where to commit this crime. And it was the defendant who chose to commit it in the middle of the day when nobody else was in the house. So no, we don't have any eyewitnesses, but that's okay, because the circumstantial evidence in this case proves the offenses beyond a reasonable doubt. And Judge Johnson is going to explain to you that circumstantial evidence is a set of facts and circumstances that tend to prove or disprove another fact by inference. There, that word, inference. It all boils down to common sense. The law states you may use reasoning and common sense to make deductions and reach conclusions. So you can take all that you do know, from the crime scene to the timeline to the statements given by each of the witnesses, and you may make inferences as to the guilt of the defendant. And I will submit to you that all of that evidence is sufficient to make you believe that the defendant committed this murder. And that's enough to prove that he is guilty of these crimes, and that is enough for you all to render a verdict. By law, it's enough for you to render a verdict of guilty. There is no legal difference in the weight you may give either direct or circumstantial evidence. You know what that means? That means that you can convict on circumstantial evidence alone. So don't let the defense convince you otherwise. Again, the law allows you to convict the defendant of each of these charges by circumstantial evidence alone. The law also states that you will be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves guilt beyond a reasonable doubt. And there we go. Reasonable. Again, it all boils down to common sense and reason. You know, I like to kind of think of my daughter when I think about reasonable doubt and circumstantial evidence. I have a 4-year-old, and we have made it our Christmas tradition to build and decorate a gingerbread house every year. That's our creation this year. Clearly, we are gingerbread artists. This past year, we made a gingerbread house about a week before Christmas, and we put it on the kitchen table, made a big deal out of how it was going to be our centerpiece for Christmas morning breakfast. But a couple days before Christmas, I was home just cleaning, wrapping presents, whatever. And I came upstairs and I looked at that, and you see that kind of clump of gumdrops on the roof. There's like orange and purple and red. I noticed that those were gone. And there was a chair that was pulled out from the table, and there were some flakes of icing next to the gingerbread house. It didn't take me a long time to figure out what had happened. Clearly, because of what I know about my home and about my family and about the circumstances, my daughter climbed up on the chair and picked those gumdrops off the roof of her gingerbread house and ate them. That's what happened. No question. Is it a possibility that my husband, who was also at the house at the time, committed that offense? Yes, but I just know him well enough to know that he is not going to eat the 5-day-old gumdrops that are sitting on the top of a nasty gingerbread house with gross icing on them. Is it a possibility that when I open the sliding glass door that you can kind of see that's behind that, a squirrel ran into the house without me recognizing it, and it climbed up the table and it got the gumdrops and took them outside and ate them? Sure, it's a possibility. But is that reasonable to believe? No. Is it a possibility that 2 armed men, one tall and thin and one short and pudgy, came into the house with guns and picked those gumdrops off the roof of my daughter's gingerbread house and left without me seeing? Sure, I wasn't in that room the whole day, but is it reasonable to believe that? No. Based on what I know about all of the circumstances of that day, I know that my daughter took those gumdrops and ate them, and I don't need fingerprint evidence. I don't need DNA evidence. I don't need an eyewitness to know that. When the defense gets up here in a few minutes, I would ask you to remember that gingerbread house, because this case is just like that. You all know the circumstances of this case, and you all are reasonable people. So think, when they talk to you, is the story that they're going to tell reasonable? What is reasonable to believe? And we're going to talk about that when I get the chance to speak to you after the defense closing.
I mean, she just went on too long about it. I thought it was fine. But then it's like, come on, we get it. Stop saying what the defense are going to say. Leave that till afterward. Also, why is no one liking the video? Is there a problem with it?
Good morning, ladies and gentlemen. We can do better than that. Good morning, ladies and gentlemen. Good morning. This is State of Georgia versus Richard Merritt. And now my opportunity to give you my closing summation. The state heard from Ms. Potter already, and as she stated, she will be coming back. The state, they have the burden the entire way, beginning of the trial, end of the trial. So they get to go first and they get to go last. I get sandwiched in the middle. Now, I just want to let you know, together we each had 2 hours. Judge, they mentioned one to we had 2 hours. What you've been talking, they give you what we think the evidence shows. It's 10:04. My hope is that within an hour, half the time I'm live, I can give you what I believe that it shows. What evidence doesn't show in this case. thinking fast and slow. We'll talk about that in a minute. But I think what this boils down to, the state wants you to think fast, clamp them down. He wants it like this. But as Judge Johnson told you, particularly she told you on Friday, that don't come to the conclusion. So all the evidence has been presented. You heard from the lawyers in these cases. I'm going to try to address about 4 things. One, some housekeeping matters. Some nuts and bolts things that I think may help you along the way. Second, we'll address some numbers which are apparent in this case. I want to echo that there are a lot of numbers that have been thrown out in all the cases you see. Third, there's the elephant in the room. And then finally, the boom mover, she gave the precursor, we'll talk about it. Emperors and flows. Housekeeping. You have it like, and our one thing. Ms. Potts said last week, this case is not easy. There are some issues that's the evidence, and then as you mentioned to you early on, this is some hard evidence to look at. Because some of this is quite graphic to look at. As she mentioned, this is not easy. One of the first things you should do is pick a foreperson. The judge is going to tell you that. The judge is going to tell you one of the first things when you go to the jury is to pick a foreperson. And the foreperson is what? It's not the person that says, hey, this is what we're going to do. The foreperson is the project manager. Someone who helps organize and say, hey, let's look at this, step by step along the way. Trying to reach your goal. The goal is to come to a verdict if you can. That's the goal, right? And the second thing is the judge want to direct you to read the indictment. It is written in legalese. It ain't easy. But it's 6 counts. But we're actually reading the indictment. Then also, what we're going to have an opportunity to do is read the instructions. When this pot is done, the judge is going to give you what's called a charge. And what that is, she's going to tell you what the law is. And she's going to tell you must follow the law. She's going to tell you what the law is and what it means, that's up to you. And she's going to give each one of you individually a copy of the law. Because the law is going to direct as to how I consider this, how I consider that. Like previously, Ms. Potts stood up and she gave a couple of sections, a couple of tidbits, put some underlines saying, hey, focus on this, focus on that. Now, some of those slides she gave you, people won't see. That is her. And she has a right to do it, giving you, I guess, her version of what it means. So as you pay particular attention, you leave it at read instructions so that you can make a decision in this case. And then each of you is going to get a path. Why? Because each of you wants to determine this for yourself. Each of you wants to determine as to the elements and as to the facts, and bring a verdict that speaks what you believe in your heart, and openly, collectively, what is told you. And let me add this. Put your questions, if you have any, in writing. In particular, four-person job, put it in writing, out the door, and we'll talk about it. Judge make a decision, she'll tell you what to do. One thing the judge is not going to tell you. The judge is not going to tell you what you heard. The judge is not going to tell you what you saw. The judge is not going to give you an opportunity to play it all over with you. No, this case extended over a weekend. But collectively, you guys have to kind of what did they say? What is the evidence? And then finally, what does it mean? Jury. I know when y'all came in on Monday, all many of you, like all of you, were not excited. The judge read you the charges. But jury duty is a very, very important task in this society. Now you have there one lawyer, President Lincoln, It's the highest calling of any citizen. To be a juror. And then another lawyer, Chief Judge Rehnquist, said, justice, you can't trust lawyers and judges to administer. It's other people. It's for the people. So that's why we asked 12 people to decide. Speak for yourselves. And of course, there's oath, which the judge gave. And we took that. We took on the job. Reaching and working through his case. And that's been your job for the last 4 or so days. And one thing the judge wants to say to this. It's hard. It's hard not to feel sorry for someone. Taking someone to climb the steps, comfort, procedures. It's hard. However, Judge will tell you not to feel sympathy from this side of the room, not to feel sympathy from that side of the room, not to feel sympathy from this side of the room. Why? Because you have a job. And you do to consider the fact without favor, that you see anybody. It's hard. It's a job. You look at the law will tell you on this side of the case. Numbers. Obviously, I'm a lawyer. Numbers is not my specialty. I went to Georgia Tech 2 years, and I left before they kicked me out. And I went back to Maryland, and that's where I graduated. Numbers is not my specialty. I realized that a lot of numbers came up in this trial. And so the way it's sort of refreshing at some of those numbers, let's talk about it. 1590 Planners Road. That's where the incident occurred. 1590 Planners Road. Stone Mountain was at Forest on Tucker. We took low, I think, 87. That's the coordinates for that address. I put a line there because actually you'll see, if you look at the attendance records, that those coordinates vary a little bit at the very end. As here's Mr. Merritt moving around the house. Now, allow is January 18th, 2019. That's the day which Mr. Merritt earned from that Cobb County case. You've heard a lot about that Cobb County case. You're complete. The judge gave him 30 years or 15 years. And the restitution occurred. I think everybody's talking $500,000 restitution. I think the record will say it's actually the restitution is $454,000, which is a big chunk of change. A lot of money. People were looking for with that. Then we talk about February 1st, 19. Now, they applied for more vacancy. That's the time period of that Mr. Merritt left the house into the house form. So between and that goes to Mr. Merritt, it looks as though they're both off by a little. And because she said he was late towards the end, so the appointment was probably 8:30, 8:45. But as we know, going from Stone Mountain up to Sandy Springs, he missed out. He got there towards the end. He saw his child, saw his wife, and he left. And then we had February 1st, he had these phone calls. Now, the state, that first one, 8:39. That's the cell phone calls, text messages. That's the text message from Mrs. Merritt to Mr. Jeffco. Now, the state asked Mr. Jeffco what time it was. He said, well, because Alabama time was actually 9:39. Except for Mr. Jeffco, he's in Georgia. He's staying there privately. And he gives information for the police. So what you see in the records, I believe it states 3, states 4, he was accurate that apparently Mrs. Merritt texted him. Mrs. Merritt texted him and she said, things are not good. Now the state keeps on saying that she said, things are bad. I think she said things are not good. Let's see for yourself. She said things are not good. Now what that meant, I'm not really sure. But she said things are not good. So go ahead, we'll meet about all the time, we'll see some other time. And then we have Richard contacts Mr. Sheffield on 9/25 with the same message. Don't worry about it, mom's gonna drive me out there. And based on hearing from two different versions, two different sources, Mr. Sheffield, he stays. Alabama. So then by 2:30 that afternoon, that's when we know Mr. Merritt left. That's when we went on the road. That's when we left the house at 1590. And by 16:14, 4:14, we cut off his project. By 1700, 5 o'clock, he was late to report. And of course, by 5:01, he was officially fugitive. Because he missed his turn in time. Now, 1716, that's a call. That's a 911 call. You see, we had asking for a safety check, for the welfare check for the house. As you heard from Officer Nelson, she told you that she was by the house, she went around it. Sergeant Holster, he shows it later. He tells her they're there for a while. They don't really see anything. You see the person inside, don't see any signs of foul play, and they leave the scene. Of course, those are the phone numbers for Richard, bottom, that sends them to know that's Shirley. And you'll have the printout on page of Burma. Then you know when the calls were, when some datas, what text messages came in, and the time frames, which those calls, as they track Mr. Merritt, 1 around 2, 5, 175. Then unfortunately on 2nd of February at 9:28, please contact me and meet Mr. Jeffrey with the driver and Fishburne. This becomes an investigation. I'll show you Merritt's body was found at the bottom of the stairs. Then we have 1847, 647. That's the warrant. Take them out, take the knife. Charging Richard Merritt Fisher with murder. That's case chapter 4, 19 CR 2140. That's what you must stop. That's in that number. September 30th, I say Richard is arrested. Now, look on the indictment. Look on the indictment, you'll see. The indictment was issued by Richard Stoltenberg. The case indicted on June 15th, June 5th, 2019. While he's still on the run, and then we was arrested. He is officially fugitive from Cobb County, and he is wanted on that indictment. That was what? 25 heirs, 8 which were accusable, 18 which they got some DNA. That's what we got. We have those 25 hairs in our hands. And those hairs, what we got? DNA, which is perfect. No surprise. And then finally, a couple hours, 12 years, we actually determined this case. So, of course, skeleton, Richard fled. He fled. He went to Nashville, took on another identity, spent time with Kelly. Yes. But that's not what he's charged with. He's not charged with stealing the phone. He's not charged with fugitive from justice. He's charged with death of his mother on February 1st, February 2nd. And of course, yes, she heard him yesterday. And she told you, on the clip, he did not kill the mother. That is the difference. And the judge is not going to tell you, well, because he disappeared, you have to do this, you have to do that. Go through the past. You won't see anything that the judge is instructing you And because he fled, because he ran, he's guilty of killing his mother. So what is the evidence regarding the death of his mother? So this woman who worked, a young associate, she had a little child. And this came on. There's a story called Emperor's New Clothes. I think it was written by, it was Hans Christian Andersen. Could be a grandbrother, I think it was Hans Christian Andersen. And the story is of an emperor. And two weavers, two tailors come to town. And these two weavers tell the emperor, hey, we're going to make the finest outfit that you've ever seen. The finest outfit that's ever been worn. And the weavers, they go to work. And they're working on these people. They're working on these people. And they're taking measurements. Ultimately, they want nothing. And on the day of the great unveiling, the emperor walks out. And everyone's like, wow, wow, wow. So finally, the little child looks and goes, he has no clothes. Passport. This case. You heard from this. And you're right. This pot said it. And it's true. Where is the evidence? Where is any of this in this case? Where is it? Listen, motive. Ms. Manicosi, she said that the house, mom put up the house. She won. The sequel of paperwork is action. She went to a bond company. I'll be the second chance bond company. The sequel of paperwork. She did not go to the house. For clarification, Richard, she took out paperwork, gave the bond company. Now, $40,000. This house is smoke rise. This house is massive. She did not sell the house. So there's no motive in order to avoid her losing the house. And then, of course, as you heard, there was no animosity between Richard and his mother. She helped provide for him. She helped provide for his wife. She helped provide for all her grandkids. She was above and beyond. No one has been in this court that said one ill word about Shirley Merritt. And as we know, because we want to make things work, we want stuff to make sense. In this case, there is no. There is no. And the judge wants to tell you, you'll see the that motive is not even proven. Now, as humans, we look for them. We expect someone to say, hey, this is why so-and-so did what they did. There's no insurance policy. There's no will. There's none of that in this case. And there's no reason why Richard Merritt took his money. Fingerprints. Now you heard from the GI. Photo fingerprints. Now you would expect there to be some, but no, there are not. Now Ms. Pot, she said, fingerprints not necessary. Someone's not necessary. That's not going to be in your bag. You must consider that when considering and determining whether or not there is reasonable doubt. There should be some, but there are. Black DNA. Ms. Pot said, well, that's not saying there isn't DNA. Well, the state is obligated to prove there was a doubt. And this case, there is no DNA. Richard Merritt, she left. And of course, tonight, dumbbell. When was it? The things like you care. About the night before the one. 3.5 years. It wasn't until April, May of 2022 that somebody looked in the closet, that somebody went in the corner, that somebody dug out of somewhere these items. Now, you don't know where they came from. We heard from the CSI that they were collected February 29th. But then what we also heard is they popped up at the GBI in April or May of 2022. Along the way, who knows what happened to these items. So what we know is, none of those items were reached there too. And of course, good impressions. They look, they figure. Of course, their confession. Have you heard Richard Merritt gets arrested up there at the thrift store in Nashville? No statement, no question, no nothing. Arrested. All right, Martin 5 minutes. There's no one saying I saw X, Y, or Z. And then of course here, there is no violence. You heard no prior, there was no problems between mother and son. You heard at best, they used to argue, names split. You heard no physical competition ever between Richard Merritt and his mother. And Ms. Manicosi, she stated, originally, she said that he never touched me, and then she changed up. She said, well, I went to therapy. I went to therapy, and I do remember some point in time, right before, that he pushed me. Now, she's talking about what they call science of repressed memory. And repressed memories are unreliable. And common sense, she said that it happened soon before the incident. Now, we heard from Ms. Manicosi, and it's clear, Ms. Manicosi hates her. And it's clear that if Richard Merritt laid hands on her, around about the time of years prior to this incident, she would have broken. She told me in Cobb County, she was digging up and finding evidence for the state. Because by that time, the Cobb County investigation hit, she hated it. She was working with the state to help commit. And of course, here's another day. She worked testifying for the state to help commit. And of course, we heard from Ms. Richardson. Ms. Richardson, she told you that at best, she remembers that made TV irritated about work schedules, about stuff at work. She said he remembered was her. And so that's Ms. Manicosi for me. She's trying to say that, well, he was a bad drunk, violent drunk. And she said, speaking with her son, she recalls some incident where he had her scared. Now, that is all. During the time, the year prior to his conviction, Richard was on her. And one condition was alcohol. And Richard violated no alcohol. So all that, it doesn't make sense. It doesn't make sense. And of course, especially Mr. Mayor and his mother. And all that he wants. Here's what it is. Having heard from CSI, they got 2 items. podcast, laptop, and also in our house. Whatever happens with us, the answer is no. We see television shows, we see podcasts where someone's Googling how to get away with murder, how to do this, how to do that, how to hide a body, et cetera, et cetera. But in this case, they have 4 devices. Nobody can be followed to see what was on those devices. And finally, we got to talk about this. In this case, lack of investigation. Now, during the pandemic, me and my colleagues, we were stuck at home like everybody else. And during the pandemic, we had lots of time on our hands. So one of my colleagues recommended this book. The book is called Thinking Fast and Slow. Then we got an annual comprehensive. And so I read the book. It was pretty thick. It was a good read, but actually I had lots of time on my hands. And it talks about, and I call it what's yacht. I don't know, it's an acronym. And the acronym is, what you see is all there is. So thinking back, so naturally, our minds work, we like to figure shit out. But figure out, hey, this is what this means. This is what that means. That's what we naturally tend to do. You look at a situation, okay, this is what it's all about, and I'm going to do this. I'm going to react like this. Intuition, not reaction. But then again, sometimes we should take slow to analyze situations. But oftentimes, there are many podcasts. I'm sure you watch podcasts, and that is the classic flaw. Oftentimes, the TV show is real popular, you go about 48 hours. You get out there and press the same thing. And oftentimes, the police take what's in front of you as if that's all there is. And they reach conclusions and they move on. And again, sometimes they're right. Often they may be right. As you've seen, oftentimes they're wrong. Oftentimes mistakes are made in corners because the evidence is not thoroughly investigated. You already saw this on regular circumstance evidence. There is no direct evidence. There's no one involved. You would go over and say, hey, I saw this. This is circumstance evidence. Where it is. Looking at all the circumstances. And you must make a decision. Now, the last paragraph. To authorize conviction on circumstantial evidence to prove that you will not only be consistent with the theory of the state's theory, but also exclude any other legal theory other than the guilt of the accused. Must exclude beyond reasonable doubt any other theory. Other than the guilt. Facts and circumstances immediately place on them grave suspicion of the crime charge or raise speculation of conjecture but defense guilt were not sufficient to authorize conviction of the same. That's the law. That's verbatim. Which you will see with that. All this stuff about what reasonable doubt is. Reasonable doubt is doubt for fair minded truth. Seeking. What did happen? In reverse. What has the state proven happened? And if the state hasn't proved it, we'll doubt. We'll get there. Let's talk about this. So, Mr. Jeffco. So we heard Mr. Jeffco, we heard about text messages. We have text messages. Told him things not good. Don't come. He acted on it. And of course, when he came later, he found his marriage. We heard Mr. Jeffco. He, good family member, cared about everybody. They were Richard, cared about, I'm sure. He came, went to the house. There's no fire, there's no protection. He found him. He called 911. The lost him in the driveway. He showed him the text messages. I was supposed to be here. He quite explained to him, I should have been here. They told me not to come. And he got screenshots of text messages. And of course, you heard Ms. Merritt. Ex-wife. She had an accident on. She told us we were living a jet-setting life. Kids in private school. Going
Not sure why he's paused. Oh my days, this is a disaster. His audio is awful. Now we're crushed.
and it sounded like she was working towards her goal in those last few days because he didn't have the car to handle it. He was in her way. She's trying to study. She's trying to reach her goal. And he's in the way. She wouldn't believe. He gets sort of like, hey, why don't you go? And he's like, well, I really don't have anywhere to go. So he's trying to stay. Here are these experts. There's Morley, there's Judith, there's Johnson. No. Now the state, they do 2022. If there was no terror evidence, there was no search center that was Richard Merritt. So out of the blue, last April and May, the state was looking for a Hail Mary. A Hail Mary would do some things, would do some hair, would do some DNA, would do chemistry. And there is none. And there wasn't. Richard Merritt not responsible for mother's death. Dr. Wagner, he's pinch hit. Medical examiner on this case, she's not available. So he went through all the information himself, along with Mr. Miller today, Ms. Winslow. He told you how the medical examiner office works. And he explained to you how she had these 2 injuries, her chest and her neck area, and the injury based on dumbbells to her head. And those cumulatively were the cause of death. Now the state said in open that she got stabbed and that was the cause of death. That's not true. Last thing he said in open that don't pay out. So the state, that's not true. He said chemically, either one over time was the cause of her death. Now ironically, part of the most striking thing is that the knife was not the cause of death. Eventually, the injuries are these two, and then the tape. And ultimately, he said within minutes before she was married, she lost her life. Now he said that also, was it one person, was it two? He can't tell you. He can't tell you. And then there was a discussion about time of death. And what he said, I can't tell you. I Can't tell you what she has. He explained to you how rigor sets in a matter of hours. And then in another set of hours, rigor breaks. Now, we heard that at the time when she was discovered, she was employed by the country. Now, of course, at the time, it was like 48, 72 hours, which is well within February 1st, February 2nd, anywhere in that time frame. Now, oddly enough, the only person who gives you a time frame, you can sort of figure out when this occurred, Richard Merritt. And he testified as this. Law enforcement. Investigator Nelson. She now works for the Federal Defender's Office. She was out there for the welfare check. She came and testified about the welfare check, and finding things. They were out there for a while, and then she moved on. Mr. Bank, he's now a high school teacher. But at the time, he worked for CSI, or Jack County. And he explained to me, he doesn't interview people. That's not his job. His job was to collect the evidence and document the photographs. And that's what he did. Photographs you have, he's the person that was brought to the photographs. The evidence, he took it in. Now, where it went after he collected it, we don't know. We know hopefully something went to the GBI, but really we don't know. That was his person testifying. They were there for the Steve Queen. Therefore, this Queen is on this slide, said law enforcement. Technically, he works for a probation office where he's in charge of handling the monitor. And he told you about the monitor. He told you about how he took the case on Mr. Mayor somewhere in midstream, and over time, just prior to the sentencing and post sentencing, he was involved with Mr. Mayor. He never met the guy personally. He monitored to make sure Mr. Mayor was doing what he was supposed to do. And apparently, Mr. Merritt was doing what he was supposed to do. Up until 4/14 on the first. And he got a notification in that monitor card. And then he went out there himself. And he used the coordinates. That's the trash. We got a picture of that. That's what Mr. Queen's job was. And he's working, of course, what that guy. And his job is to look at records, data records. Cell phone records, most commonly, every now and then he does look at these monitor records. And he's going to map exactly where Mr. Merritt was on February 1st. That, like I said, morning into afternoon, into this late afternoon. That's what he told you. He gave you that information. Now, can he tell you what Mr. Merritt was doing at the time piece? No. He can say about the flight. He can tell you about that information. But that's not what the case is. That's not what the case is. US Marshals. Marshal, he works for the Jack County Sheriff's Office. And he's involved with computers. And what he does is he gets paperwork from various locales, various departments. He gets together and he investigates. And he tells you how we got a tip from the car, we looked Nashville, found the car. After that, we came back, then we went back to Nashville and sat on the area, and we found some medical pistol and the rest of the others. Now, detective. What's interesting in this case is that no one that you heard from currently works with the staff benefits board. No one that you heard from will be detected. Now, we know the things were involved. CSI told us they were involved. We know the things were involved because you'll have a warrant. You'll see the detective knife took out the warrant. You know the things were involved because Mr. Burnett told you it's their job to investigate and interview people. We know they were involved. What did they do? What did they determine? Nothing. Because in their mind, what you see is all there is. In their mind, what you see is all there is. So the investigation was this. February 2nd, 9/28, the mayor's bottom half. At 3:42, the same afternoon, CSI legal scene. Evidence been collected, posted, and taken. 1. 3 hours, 5 minutes later, the warrant is taken out. 3 hours later, that's the entire stage. By this time, no Mr. Merritt gone. No Mr. Jeffrey on the scene. That's it. There was no investigation. To the police. He's gone, she's dead. We're done. That's all that matters. Closed case, move on to the next one. That's the whole investigation. Now, what do you do with that? Do you accept that? This is a criminal case. Don't overstate it. When we go forward, I make a decision. What do we do with that? Is that good enough? The state's told you that it's easy. It's easy. That's what they want you to accept. Hey, that's it. And why did they try to accept that? That's all it was. Because we know it's an investigation. Finish up the timeline. It's indictment. Of course, it's still nowhere to be found. That's the case. So, sometimes on Friday nights, try to set some time. Try to get together. Bring everybody downstairs. And let's see what's playing. Let's see what's that cake now, all types of streaming services. Let's see what's playing. And the family sits down and hit the button. See all these various options. What do you do? Play the trailers. Play the trailer, and you're like 2-3 minutes snippet. And you watch the trailer, and you're like, okay. No. And because of those 2 or 3 minutes, you hope to get enough to see whether or not it's interesting, whether or not it's something that fits you, and oftentimes it's something whether or not that you can figure out. That's what we try to do when we watch trailers. We're trying to figure out what this movie's all about, right? Because when you look at the trailer, if the movie doesn't make sense to you, you go to the next one. If the trailer doesn't sort of tell you a story about how you have a protagonist who fights through this in order to overcome, like, I don't know about that. What do you do? You think fast. Because you want to try to get to, you want to try to figure out, okay, this is what it's all about. This means it's not. Like in my house, you take a vote. And whoever wins, the majority usually wins. Sometimes I'm like, no, I can't watch it. Sometimes I use my authoritarian powers to watch what I want to watch. But generally, okay, let's vote. Let's watch this. But then every now and then, the movie comes on, and starts off with big action scenes or big scenes where maybe with demons or a mystery or some action. And you watch the movie all the way through, And you're like, wow, that's not what I was expecting. Because in the course of that 90 minutes, 2 hours, 3, 4 hours, things unravel, and you're like, oh, wow. And of course, a good movie makes you think a little bit. Sometimes you watch a comedy, you're not trying to, you watch a success rate, you actually, you want to think a little bit. And you use your analytical skills. Are you thinking through the movie? Are you thinking slow? Like, hey, this is what this is all about. And it's not a lot of problems. In this case, this pot came on last week. She told you what this is. And the book said, wait, because it ain't that simple. And the state conceded it's not that simple. Why? Because as we talked about, there was no investigation. Why? Because there is none of this. What happened? I think it's possible to give you a theory. Was there the support? Or was it just a theory? You're Mr. Merritt. Mr. Merritt, he gave you a theory. Reasons you decide on that. But in the end, the state has to disprove what he said. And the state must prove what they claim. That's what must happen in the space. Presumption is the burden of proof. We heard it before, we'll see it again, see it back. They have the burden. The entire trial. From the beginning to the end, they have the burden. And that lack of investigation, that lack of evidence, Ms. Pottle said, you look, you got enough on that puzzle. You got enough pieces? You know what it is? No. You can guess what it is. You can speculate what it is. It has to say proven what it is. Was that a leopard? Was that a tiger? The state must prove what it is going to be without. And the state falls short. If the state falls short, you must. The judge will give you in charge. And you'll see this word must in there a few times. Particularly, you'll see it in burden of proof rests on the state to prove every material allegation. Within that. And the material allegation is Richard Merritt did this. That's material allegation. But if the state fails to prove charges beyond reasonable doubt, you must quit. And Ms. Pott said, you just ask this question. You just wait this up there. Gingerbread houses, you make them 2 for Christmas. This isn't a gingerbread house. This ain't no game. This ain't no fun. Anybody can judge these. Go house. It's a trial. And if you look at the evidence, if the state has got questions, the state should be answering. The state should be explaining about any type of hearing. Why would we hear from anyone about what did happen with this evidence? Why was it not tested? You know what? Nobody cares. He's gone, she's dead, done, dusted, over. That's not the law. Because the state has the burden each and every step of the way. The police, the investigation, it goes down. Lack of any type of evidence, that goes down. And they should have to account for that. And the folks in place, these said the first thing in society is justice. I anticipate, she may not, it's possible to take justice for Shirley Merritt. That is not her job. Justice is a simple, justice is the end and the administrable laws in this country. It's not a matter of justice for Richard Merritt, it's not a matter of justice for Shirley Merritt, it's a matter of justice for our society. And that society is what? Us. Us citizens who live in Gap County. Us citizens who live in the state of Georgia. Us citizens of the United States. "20, 25 years later, people will ask me, Daryl, what do you think about O.J. Simpson?" And I'll tell them this. 12 people decided that case. They heard all the evidence. They decided that case. And I think just likewise, people tell me, Daryl, we know who killed Trayvon Martin.
Sir, I'm object. Comparison of this case to other cases.
I'm not comparing cases. I'm not comparing cases, Judge. I'm making no comparison between this case and Mr. Merritt's case. And I tell everyone, 12 people decided that case. They heard all the evidence, and they ran the verdict. Sure, $8 wise, the state and I disagree. That's why we're here, until we disagree. But in the end, yes, we chose no. We chose no. And the judge is tasked and empowered to decide this case without favor or passion. And you must determine each and every element of the case. You must determine whether or not the state has met its burden to prove Richard Merritt guilty or not. And also, yes or no. I'm asking you to find Richard Merritt not guilty. Thank you.
Gentlemen, does anyone need a break before we hear the final closing from the state?
Yes.
All right, let's take a break.
Yes. That was awful. What the fuck? That offer, his audio was awful. It was all echo, we couldn't stand him. What the hell was you on about? Honestly, they're both just as bad as each other. Oh my days. Oh, stretch now. I've just seen people pop out every 2 seconds of the stream. I'm not sure what the vote was like for you guys. It was awful on my side.
Ms. Campbell is going to give you each 2 copies of the final charge for you all to take a look at. Okay, I have one.
Oh,
Be in recess for 15 minutes.
3 minutes. So, yeah, the NFL one's doing all right. We'll catch up quite quickly on that one. And even, we'll watch that Spider Girl. It's all good. So just a reminder, we're watching 2 streams. We'll watch the jury instructions and then we'll switch from this stream and we'll start a fresh stream. It's already been started. All I need to do is start it on Rumble, which probably will take me 5 to 10 minutes. Probably it's only 5 minutes, but I've got to pour the codes in, everything like that. It's a faff, it's more than anything else, because you can only stream one video. You can't set up multiple videos on Rumble, which is a shame. So yeah, go for your breaks now, whatever. 2 secs. Okay. for the Detroit Lions hoodie, like an old one. Oh, it's in transit, but I don't know what that means. So yeah, so here we are. Here we are again on my own. If I copyrighted because of my voice. Oof. Right. State to just go their last bit to say, geez, I hope she just hurries up. I mean, I don't know what else she's going to say now. Can we get the fuck on with it? Oh, she's boring. So then we got that. We got um, jury instructions, which I hope they do straight away. I hope they don't go to lunch and then jury instructions because that's going to be a nightmare. Just the whole case, cuz you've literally missed the whole case. Just closing statements for. Oh, sorry, I'm so tired right now. Closing statements for the state, closing statements for the defense. Both were absolute rubbish, or both were boring. And then there's going to be a rebuttal now by the state, which no doubt will be boring. And then we got jury instructions, and then we close this stream down, and then we will go and watch the NFL one at another stream. That's the plan. Yeah, but fair, yeah. You don't watch this trial at all, have you? Missed it. The alternate corner mug. Don't even think I sell these anymore. I got other styles now that I sell instead. Saying that, maybe I do sell them. I have no idea what's in the store. Um, no, yeah. No, I didn't. He's a lawyer, but it's for civil cases, not criminal. So no, he did represent himself. Obviously, he knows the layout of it. He knows roughly what's going to happen, but no. He had two attorneys, one woman, one man. The woman's a fitty. So yeah, I'll be break now, guys. Do all you need to do. It's 11 o'clock with us here now in Wales. My days. I understand it's a circumstantial evidence, but I just can't believe his story. I just can't. So, for me, the guy's guilty. So, coming from me, that's something because I find it quite hard to find people guilty. I try and always look at every inch to make them not guilty, but not with this one. I think he's guilty. Just everything points to guilt, I think. Literally everything. I Because if you were if someone else actually did kill her, then they just created the perfect murder. Can you imagine two guys actually came to the door and did all this? No one believes it, so I was like, oh, get away with it. No, I think we got the right guy. I don't know how you do that though, but hey, each their own. We don't know what he's going through, but yeah, Jesus, I'm so sorry about yawning. Things late last night in bed, streamed all day yesterday, and I think it was just a matter of listening to these two speak was just to what everyone else think. I'm not going to do a poll because there's not too many people here, but I've got him down as guilty. Carwyn hasn't got a clue because he hasn't watched it. Anyone else? Guilty, not guilty? Be here. I'd be thrilled to hear some not guilties if there's anybody. You don't have to post guilty, not guilty, but as you always, it's nice to hear other people's input. You get a feeling the lawyer that it's not going. Oh yeah, I think he knows. I think I think the whole courtroom knows it's not going his way, personally. But again, we don't actually know because we're not there. The jury might think completely different to us. Or to me, then, sorry. So it's impossible to actually know. Do you know what I mean? So. Mm, 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 mm. Ba 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 ba. Hmm. Yeah, well, so I'm just trying to look what's going on. So yeah, hopefully the NFL one will be good as well. Start that today. A few weeks with that bad boy. Travis Rudolph. Travis, the red-nosed reindeer. Ba 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 hey ba 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 ba. Oh, another few minutes. Take a break, guys. Take a slash. Go get your coffee. Go get your teas, whatever you have, and hopefully we'll be done in the next hour. Hopefully, we'll take a short break after that, and then we'll get going with the NFL trial. Okay, so there's not much going on. Just looking there now, Roy. I bought a Zachariah Anderson t-shirt today, so that should be on the way. So yeah, if you haven't seen it, Zachariah Anderson's a good trial to follow. I still to this day can't believe he was found guilty. I think it's one of the biggest injustice I've seen, in a trial. Anyway, certainly. I know some people disagree with that, and that's fine. We can all be respectful. It's all good. What have we got here? Um, ba-da-ba-ba-ba.
Chat. My mom doesn't even show up in chat. Very rarely. Uh, Yay, over 700. Get the court. You know what's funny? I still have like 2 bottles of undrank wine where we hit the milestone faster than I can drink. I have to start slowing down on the corks because I'm going through wine like crazy. So we'll do the next one. Maybe we should do save them.
Um, I'm interested myself now as well. So people think, why are you quiet? I'm just checking some stuff online because there's only a few people here. I don't expect people to mind.
You just. Well, let's check out. Let's see if Bungalow Jonathan has anything else. Wait, Bungalow Jonathan has a music video? Oh boy. Spitting mustard down the jewel tree. Spitting mustard.
Okay. Looks like they're coming back, which is a good thing.
Thank you. Put down. Section 330. Take off.
To the Law and Crime Network, I'm Linda Kenny Bond. Well, Brian Koberger was seen.
Okay. 3 more minutes. I don't have anything to add to it because I don't think there's. I'm going with he's guilty. I'm just thinking, anyone else got anything? Okay. Hey. Right, here we go. It's about to start back on now, right? Trying to finish off here. We'll get to it now. Let's get back into it. So that was my break as well. I'm just tired. It's up till about 1:30 this morning. I was back up early 8 o'clock this morning, so not had much sleep. I'm tired. So apologies for that. Am I not entertaining you, motherfuckers? Here we are. Merritt's back. So you had massively long hair. Look at her, the 50 lawyer. Look at her. Oh, can you see it? Yes, cutie pie. Oh, I prefer her hair in a bun to being down. She looked really cute yesterday. So, oh, nice. It's a nice, Borat, nice. Borat in Welsh. Bam, bam. People play music videos. I don't. I'll just sing it. Bam, 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 ch, 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 ch. Just gotta be, careful I don't get copyrighted or something. Dee 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 dee. Dee 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 dee. Bum 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 bum. Come on, come on, Harry. Oh, wouldn't he be? Bum ba da bum ba ba bum. Oh ho ho ho. This could be magic. Oh ho ho. Hee hee hee. Ba da bum ba da bum. Huh? Stop! What are you talking about? Cheeky. Just remember, I can, mute you. I think I've got a great voice. There was once a little boy or girl. You know what? They don't say anymore. Boy, girl, what are they? This, that, they. World has gone mad. Look at her. She's looking at. Oh, look at her sucking on Astra. Hello, cutie pie. Did look like she's looking at me then as well. Obviously, no, she's not. Don't worry. Oh, okay. So I could continue singing, and that's fine. On Thursday. I mean, I just think she's absolutely, I mean, you guys can, be thirsty with Johnny Depp and stuff. It's not have to be gay, compliment a woman. She's absolutely beautiful. Don't think there's anything wrong with that. If you want to compliment Richard Merritt, you're more than welcome to. I won't stop it. I better stop singing because everyone just left. Bloody hell. The worst thing is, everyone in Rumble we just increased in size. Here we go. Well, thirsty comments. Yeah, I mean, she's lovely. Hi, Giovanna. You alright? You have a nice break. Well, I think I know you're teasing. It's all good. As I said, you could say about Richard Merritt. Good-looking guy. Not my type, but I mean, everyone can say whatever they want. No religion, no politics. That's about it. It's whatever. We all know that by now. After the Mark Jensen trial. Lefty. What's your type in Spider Girl? I was just talking about this attorney in front of us, the woman, Lefty. I think she's a right cutie pie. You know what I mean? And I was being accused of being thirsty by Spider Girl. What's your type, Spider Girl? Is the other lawyer your type? Bit of beard? Here they go. well, Johnny Depp's Jensen's sentencing's been, boy. It's been. It was a couple of weeks ago. I did put it on my channel.
Y'all may be seated. Ms. Pot, if you're ready to proceed.
Yes, Your Honor. You know what's really telling about what Mr. Queen just said? He spoke for, I don't know, maybe 30 minutes. You know what he never mentioned? Is the story his client told when he took the stand yesterday. He talked a lot about what the evidence wasn't. But the whole purpose of that was to distract you from what his client said on the stand and what the evidence is. Let me give you an example. He talked about how the Detective McQuilkin, did not testify in this case. Well, you know what a detective does? A detective doesn't create evidence, and a detective is not evidence. A detective gathers the evidence that you see in trial. Who do you think took those search warrants out to get the phone records?
What are we doing, Jack? Facts on evidence? We don't have a public search warrant.
Your Honor, I'm not speaking of any fact, just about how the detectives collect evidence.
All right, the jury will recall what the evidence in the case was.
How do you think we get surveillance videos? How do you think we get in touch with witnesses? Who do you think interviews them and takes their statements, which of course don't come into evidence because they're hearsay? You don't need to hear from the detective because you heard and saw the actual evidence in this case. Another distraction, whether the footprints on the floor in the basement, well, you saw that basement, it was pristine. In fact, one of the lies that I think the defendant told was that he lifted 3 or 4 times a week when I talked to him on cross-examination, because you saw the floor, the carpet, where that dumbbell had been sitting. It had the impressions it hadn't been moved for weeks. Ladies and gentlemen, they are all distractions, and there were plenty more. Plenty more. And you know what they are. So I'm not going to go into all of them, but I want to go into what the facts actually are in this case. Mr. Queen talked a lot about numbers. He put the slide up with all the numbers all over the place. Those numbers are evidence, and they tell a story. They tell the story of what happened the day before, the day of February 1st, 2019, and after the defendant fled from that crime scene. And it puts the defendant at his mother's house for a period of time. And let's just go over them. First of all, we know that the defendant woke up and he left the house at 8 a.m. that morning to go to his doctor's appointment. He got to the doctor's appointment and he was quiet. Folks, he was brooding because he was thinking that he wasn't going to turn himself in that morning. He arrived back at the home at 9:38 a.m. and he had already had a discussion. It's reasonable to believe that he had already had a discussion with his mom saying, "Mom, I do not want to turn myself in." Well, clearly, based on the evidence, Shirley Merritt did not agree with this. She had his birth certificate, his paperwork out. She was making his last meal. She obviously didn't want her son to go to prison, but she wanted him to do the right thing. And the right thing was that he was going to turn himself in as ordered at the time that he entered his plea. So she wrote that text message
to Mike Jeffcoat just a minute or two after her son arrived back home. And you know what's really telling about that text message? She says, "Things are not good here. He has a lot of things we need to talk about." Now, Shirley, as you heard, was an emotional person. She would have been too emotional to drive the defendants to the jail, as you heard from Jeffcoat, as you heard from Janine. Everyone believed that it was a good idea that Mike drive into town and that his wife sit with her so that she wouldn't be alone. Because they were concerned for her safety and for her driving that distance to take her son to the jail and what would happen. Now, the defendant testified yesterday. He said, yes, they did have a lot of things to look at. You know what he said those things were? He said, "We had to organize my clothes. We had to decide what of my personal items we needed to sell or she should sell." Do you think that's the reason that Shirley sent that text message? Do you think that she called Jeffcoat off to say, or because she needed to talk to the defendant about where she was going to store his clothes and his stuff? No, it's not reasonable. And that's the first part of the defendant's story that just doesn't make sense. What is reasonable to believe that happened? She probably knew that the defendant was on the fence about going to the jail that afternoon. She didn't want Jeffcoat to come because she knew that she needed to have that conversation with her son and say, "You need to do what's right." And even though Jeffcoat was a close friend and a confidant, she didn't want him to get in the way of that and be involved in that. So after that text message, the defendant leaves home. He leaves Planters Row at exactly 2:30 that afternoon. So he's there between 9:38 and 2:30. And we know that at some point during that time that Shirley started cooking lunch for the defendant and that he took the knife out of the kitchen and that he stabbed her, that she ended up at the bottom of the stairs and that he finished her off by bashing her head in with the dumbbell. It was during those times that the defendant killed his mother. Now, I can't say for certain what the conversation was between the two of them. I can't say for certain how Shirley Merritt ended up at the bottom of that staircase, whether she fell, whether he pushed her, or whether he chased her down there. But what is reasonable to believe is that Shirley started having a conversation with the defendant and told him that he needed to turn himself in, and he went off onto one of those rages that his ex-wife had described. He lost it. He lost it. He was not going to turn himself in that day, and the one thing in his way was his mom. And that knife just happens to be the convenient weapon that was in the kitchen where she was cooking, and she fell down the stairs or ended up down the stairs as he was stabbing her. He stabbed her in the jugular. She was on the ground, only had a few minutes left to live. He stabbed her in the face and the handle broke off of that knife. He heard her moaning and just couldn't stand the sound because he had things to do. He had to take a shower. He had to pack up his toiletries. So he grabbed the convenient thing, the weight that was in the basement, and he finished her off. Folks, that is what is reasonable to believe happened in this case. I'm not saying that we have to prove all of those events, but it is a theory of the case that is reasonable. The defendant stopped at QT at 5:52 p.m. He was in Shirley's car, which he had stolen. He had her cell phone, which he likely took so that she wouldn't call 911 or wouldn't call Steve Queen, the ankle monitor person, who she had been in touch with, and he testified that she had been in touch with. He testified that they had been in touch before. The defendant is not going to turn himself in. He's trying to get as far away from the crime scene as possible because he doesn't want his mom's body to be found. So he takes that Cass Road exit at 4:12, and at 4:15, he cuts off his ankle monitor, throws it in the trash underneath a pizza box. Now, at 5:39, the police get there. There are no broken windows. There is no overturned furniture that they can see from outside. The doors are all locked because that's the way the defendant left the house that day. And then the next morning, Mike Jeffcoat drives into town and he finds Shirley's body stabbed and beaten on the bottom of the staircase. It is up to you, as Judge Johnson will explain, to determine the credibility of the witnesses. You can believe them. You can choose not to believe each of the witnesses that testified, and that includes the testimony of the defendant. And I will submit to you, ladies and gentlemen, that the defendant's testimony was not believable. Judge Johnson is going to list some factors that you may consider. It's not, you can consider other factors as well, but by law, you may consider his manner of testifying. Now, this is a guy who told you about his mother being murdered by the two guys who just happened to force their way into his house. He showed no emotion during his testimony. You know why? Because he's been practicing for 4 years what he's going to say. His testimony conveniently matches the crime scene photos and the evidence, which he has been in possession of for 4 years in the discovery that he received from the state. You can consider the probability or improbability of his testimony. We're going to talk about the improbability of his testimony in a few minutes, but I'm just going to submit to you. Did anything about what he said make sense? Was any of it reasonable to believe? You can consider the interest or lack of interest in the outcome. Again, that's pretty important. The defendant is facing murder charges, and he has every reason to lie to you all, the jury, who are deciding his fate. You may consider his personal credibility. I will submit to you that there is none. He admitted to lying to his clients, to deceiving his wife and family. He admitted to lying to his employers in Tennessee and to Kelly Richardson, who he said that he cared about, but I will submit to you that he was using for a place to live. He made up an entire persona for himself under the name Mick Malvo. So why would you believe him now when he has everything on line? And finally, Judge Johnson will instruct you that you can consider whether the speaker, whether the person testifying has any prior convictions for crimes of dishonesty. You're going to have the indictment to which he pled guilty in Cobb County just 2 weeks before he murdered his mom, and you will see that this man is a serial liar.
that story that he told you yesterday, I want to be the first to say it. Mr. Merritt, that story was BS, and we don't believe you. I am going to ask that you tell him that as well in the form of your verdict. You know, to believe Mr. Merritt's story, first of all, you would have to believe that his clients who he stole from, who he admitted were in their 60s and 70s, hired two hitmen or somehow got these two monsters to go into the house and cause some kind of havoc. It was interesting the way he described them. He said that the one was tall and thin and wearing a black thermal shirt, a pair of Dickies. The second one was shorter and pudgy and wearing a camouflage hoodie. All I could think in my head while he was testifying was the two bad guys, the bandits from the Home Alone movie. Remember, there was Joe Pesci and the tall guy. Clearly, he hasn't been watching John Wick for him to come up with that description. And these two bandits, these two bad guys, these two monsters, they did not attack in the middle of the night, but after driving around the cul-de-sac 20 or 30 times in the weeks prior to the murder, they decided in the middle of the day, about 1 o'clock, to politely knock on the door. And then you have to believe that the defendant, after seeing them through the windows that are clearly on the side of the front door, that he opened the door for them. You would have to believe that both of the bandits had guns on them, and that they held both the defendant and Shirley Merritt up at gunpoint with guns to their backs and gave them orders, but they never shot those guns. Instead, they decided to go into the kitchen and get a chef's knife, which they used to stab not the defendant, who is the person that they were after, but Shirley, his 77-year-old mother. And they didn't use their guns to finish her off. Instead, they decided that it would be more convenient to use the dumbbell that they found in the basement. And then these two criminals, who were obviously pretty professional because they had photos of having seen the defendant's family on their phone. No, they decided that they would leave the murder weapons at the scene to be found by the police. You would have to believe, ladies and gentlemen, that these monsters, these bad guys, these bandits, after the defendant, who was the person that they were after, watched them brutally attack and kill his mother, that they said, go, here's the princess treatment. Ladies and gentlemen, the mob does not let their witnesses go. And yet they did with not a scratch on him and a warning. Just a warning. Don't tell anyone or else. You would have to believe that the defendant then took Shirley's car, because it was the one that was full of gas. And you know, that actually is true. But that he took her phone because, as he testified yesterday, what if they called with demands? He was going to pick it up. But just a couple of hours later, he got rid of that phone and it went off the grid. As Special Agent Bernie testified, both the defendant's phone and his mother's phone, they stopped working. They were turned off, discarded somehow. again, to believe the defendant's story, you have to believe that this defendant was terrified for the safety of his family, so terrified that he got out of there. He left and turned himself into the jail, which would have been a safe place for him to go, even though he passed the exit where his son's school was. And even though he passed the exit where his wife's practice, veterinary practice was, he never took those exits to go give his family a warning. He never called police. He never called any friends to tell them, listen, my family is in danger. Please do something. And then you have to believe that even though the defendant was terrified about what he had just seen, that he stopped at a QT about 30 minutes later. He pumped some gas. He was there for 7 minutes, and he bought water and he came to park. What about his statement was reasonable? You know, the law states that to convict on circumstantial evidence, the evidence as shown must exclude every other reasonable theory. Every other reasonable theory. Well, you have a theory. It's the defendant's theory. But not a single thing about it is reasonable, because not a single thing about it is true. The law does not require you to think up theories in your mind that could have possibly, maybe happened. You are allowed to convict on the state's evidence. You know, I have 2 hours to speak, and I am tempted to stay here all day because there is a lot that I can say. But y'all are intelligent people, and you all know what the reality is based on what you presented to me for the past several days. You can see the obvious, and you all are allowed to convict based on that, based on what's right in front of your face. I'm a mom. I know that many of you are parents as well. And I truly, truly believe that a good mom, like Shirley Merritt, a good mom's love is going to transcend anything. It's going to transcend lies. It's going to transcend deceit. It's going to transcend the horrible acts of her spoiled brat child. But that doesn't mean that Shirley doesn't deserve justice here on earth. Ladies and gentlemen, I want to thank you all for being here over the past several days. I would ask that you go back into the jury room, look at the facts before your eyes, and convict based on those. I'm going to ask you to find guilty of malice murder, guilty of felony murder, guilty of aggravated assault, and guilty of possession of a knife during commission of crime.
Thank you, Ms. Pott. Ladies and gentlemen, I am now going to instruct you on the law that you are to apply to the facts that you've heard during the course of the trial. This will take me about 15 minutes or so to read it to you. You will all receive a copy of the charge as well as the indictment and a verdict form when you go back into the jury room to begin your deliberations. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented, then you must apply the law I give you in the charge to the facts as you find them to be. You are considering the case of the state of Georgia versus Richard Merritt. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, aggravated assault, and possession of a knife during commission of a felony. The defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, this burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crimes or crimes charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the question and issue. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit, If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean that you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. You have received in evidence a prior conviction of the defendant. You may consider this evidence only insofar as it may relate to attacking the credibility of the defendant and not for any other purpose. In determining the credibility of witnesses and any testimony given by them in court, you may consider, where applicable, evidence offered to attack the credibility or believability of any such witness. This would include evidence of a felony conviction, proof that the defendant has been convicted of the offenses of theft by taking, elder exploitation, forgery in the first degree, and forgery in the third degree. A crime of dishonesty conviction, proof that the witness has been convicted of a crime involving dishonesty. It is for you to say whether, under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crimes alleged in this bill of indictment. Certain evidence of fingerprint comparison has been admitted by the court for your possible consideration. Identification by fingerprint comparison is opinion evidence and is dependent upon the credibility or believability and accuracy of the expert witnesses called for that purpose, as well as the following factors: the validity of the theory of identification by fingerprint comparison, the credibility of the witness who performs other necessary functions in making the comparison, such as ink fingerprint impressions and latent lifts, and the accuracy of procedures in identifying, preserving, recording, and maintaining integrity of the physical evidence, all of which are questions for the jury. Fingerprint evidence is also governed by the rules on circumstantial evidence. If you believe that fingerprints corresponding to those of the accused are found and identified, their evidentiary value, if any, would be diminished to the extent that they could reasonably have been left on the article alleged at a time or under circumstances that would be consistent with innocence. A verdict of guilty may not rest upon fingerprint identification alone. Unless you are satisfied beyond a reasonable doubt that fingerprints left by the accused were in fact found and that could only have been impressed by the accused on the weapon at the time of the commission of the crime, and that such identification, under all of the facts and circumstances of the case, is sufficient to satisfy your mind of the guilt of the accused, to the exclusion of any other reasonable theory and beyond a reasonable doubt. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. You have heard evidence of the character of the defendant for a particular trait, more specifically character for nonviolence, in an effort to show that the defendant likely acted in keeping with such character or trait at pertinent times or with reference to issues in this case. This evidence has been offered in the form of opinion of a witness. You should consider any such evidence along with all of the other evidence in deciding whether or not you have a reasonable doubt about the guilt of the defendant. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. The law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in DeKalb County, is a jurisdictional fact that must be proven by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. As to count one of the indictment, malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be sufficient provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. As to counts 2 and 3 of the indictment, felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault, as alleged in counts 4 and 5 of the indictment, are felonies, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or as shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. As to count 4 of the indictment, aggravated assault. For aggravated assault, as alleged in count 4, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether the dumbbell, as alleged in count 4, is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. As to count 5 of the indictment, aggravated assault. For aggravated assault, as alleged in count 5 of the indictment, the state must prove that the defendant assaulted another person with an offensive weapon. And as an additional element of the offenses charged in count 5, the state must also prove that the alleged victim was over the age of 65 years old. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether the knife, as alleged in count 5, is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. And lastly, as to count 6 of the indictment, possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade of at least 3 inches long on his person while committing a felony, which is a crime against or involving another person. The offenses of malice murder, felony murder, and aggravated assault are felonies under the laws of this state and are defined as previously stated. Now, ladies and gentlemen, in addition to the indictment in this case that I read to you on the first day of trial, you will also have a verdict form for your use back in the jury room when you begin your deliberations. You will be considering each of the charges in the indictment individually. And the verdict form, once you get to see it, you'll see it's pretty self-explanatory, but I just want to make sure that you understand that each of the charges are set out in the verdict form. So for instance, it says, as to count 1, malice murder, we, the jury, find the defendant, and there's a line for guilty and a line for not guilty. And likewise, as to the other counts, 2 counts of felony murder, counts 2 and count 3, 2 counts of aggravated assault, counts 4 and count 5, and count 6, possession of a knife during the commission of a felony. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in DeKalb County, Georgia, did between the dates of February 1st, 2019 and February 2nd, 2019, commit the offenses as alleged in the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to any communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. The following is the instruction for any jury communication to the court from outside the courtroom. Any jury communication to the court must be in writing. Parties will be informed of the content and the writing will be marked as an exhibit and entered into the record. The court must allow counsel to suggest an appropriate response, and the court must inform counsel of its intended response, and the court must allow an opportunity for counsel to respond. At this time, I have to inform our alternate jurors, jurors 37 and 41. 37 and 41. Okay, all right. That you will not be permitted to participate in deliberations, but I cannot excuse you until we know that you will not be needed. So once the jury begins their deliberations back in the jury room, you'll be escorted to a conference room down the hall so that you all can sit, and if the jury decides to take a break, if you want to go with them on the break or have lunch, you're welcome to do so, but you just can't participate in deliberations at this time. Now, ladies and gentlemen, we're a little late for our lunch break. It's 10 after 12. So one of the first things that I would like for you all to do when you go back into the jury room is to send us a note to indicate whether you want to go ahead and take a lunch break. And if you do want to take a lunch break, how long you want to break, and what time you'll be back. At this point, you all are driving the car, as I call it. I have given you instructions about the times that you go to lunch and when you return, and when you recess, all throughout the trial. But at this point, the case is in your hands. So you all just need to give us some direction about whether you want to go to lunch, whether you want to go now or start deliberating now, or whether you want to come back after lunch and begin your deliberations. You should not be discussing the case until all 12 of you are present in the jury room and you have the evidence that's been admitted and the indictment and the verdict form and the instructions from the court. If at any time during your deliberations, someone needs to take a break, someone needs to go to the restroom, or you just need a break from the discussion, you have to stop talking about the case and wait until everyone is present at the table in the jury room and participating in deliberations before you discuss the case. It is very important that you keep in mind the instruction that I've given you and the instruction that I just read to you. Your decision about this case must only be based on the evidence that you've heard, the instructions that I give you, okay? No independent research, no contacting friends or family or anything like that during your deliberations until I accept your verdict in open court. All right. You may now retire to the jury room, but please don't begin your deliberations until you have all the evidence and the other documents. And please let us know whether you want to go to lunch.
So with that, I'll be closing this trial down, taking a 45-minute break to set up Rumble and have something to eat. And then hopefully you all join me in the NFL trial. Don't worry, I'm still going to keep an eye out on this one. And when the verdict does come, whether it's today, tomorrow, Friday, whatever it is, we'll pause the NFL one and we will watch it live.
Any exception to the charge from the state? No. From the defense? All right. All right.
Do me a favor.
Let's go over the
this
evidence while we wait for the note.
Like this video as well if you can. Right, I'm not going to stay for the evidence bit. I don't think we need to do that. They're just putting evidence through, so I'm not going to sit here and watch that. Hello, 250s. I'll watch them today. Look at them. Both of them are lovely. Anyway, with that, hit the notification button, see when I go live, or just go to my channel, or the link's going to be on Twitter. Thanks for joining this one, guys. And if you're watching this on repeat, there will be a video after this with the results as well. So that's it. That's all I've got. So hopefully see you all in about 45 minutes. See you there. Ta-ra.